Welcome to Tomkins Talks. It's time for another summary of a recent case in a short, snappy way that's easy to digest, whether you're at home, as I am today, in the office, or on the move. Today I'm going to talk about the case of Capitol Park Leeds Plc and Global Radio Services. So let's get started with the backstory. When a tenant exercises a right to break a lease, it must strictly comply with any conditions attached to that break. As in sport, and as Martin Guptill can attest, there are no prizes for coming close. A condition frequently attached to a break is that a tenant must yield up with vacant possession. In order to satisfy this condition, generally speaking, a tenant needs to get over two hurdles on the break date. First, it must not be using or occupying the property. And second, there must not be a substantial impediment to the landlord using or occupying the property, or a substantial part of it, on the break date. Now, this case concerned a property on Capitol Park in Tingley in Leeds. The tenant, Global Radio, had a lease for a term of years expiring in 2025, but including the right to break on the 12th of November 2017. Global had to comply with a number of conditions in order for the lease to end on the break date, including one to give vacant possession of the premises to the landlord. Global didn't have an ongoing requirement for the premises, so served a break notice in February 2017. Prior to the break date, it carried out various works to the premises to seek to mitigate its potential dilapidations liability, including removing various items listed behind me from the premises. As you'll see, these items included removing ceiling grids, radiators, and emergency lighting. Now, there were various discussions between the parties' representatives prior to the break date as to the works carried out by the tenant. In short, the tenant ceased carrying out works to try and agree a negotiated settlement with the landlord, but that was not concluded. By the time negotiations ceased, there was not sufficient time for the tenant to complete its proposed works, so it handed the property back to the landlord on the break date, with the various items having been removed and not replaced. So the landlord asserted the tenant had failed to give vacant possession of the premises on the break date. It pointed to the definition of the premises in the lease, which included the existing building when the lease was granted, and, importantly, all fixtures and fittings at the premises whenever fixed, except tenant fixtures. The tenant responded by arguing that the requirement to give vacant possession did not require an assessment of the physical condition of the premises. So what was the outcome? Well, the trial took place in the High Court in Leeds in August, with judgment being handed down on the 23rd of October. The judge was satisfied that the tenant failed to give vacant possession of the premises to the landlord. He came to this conclusion on the basis that the premises, as defined in the lease, included fixtures and fittings, and by effectively handing back an empty shell of a building, which the judge said was dysfunctional and unoccupiable, there was a substantial impediment to the use of the building by the landlord. Another issue the judge considered was whether discussions between the parties' representatives had created an estoppel, such that the landlord could not rely on the tenant's alleged failure to give vacant possession on the break date. The judge found that no such estoppel had arisen. As such, the landlord won the day, but do note, permission to appeal has been granted, so watch this space. So what does this mean? Well, the judge did comment that this was an exceptional case, and I do think it's pretty unlikely that most tenants will act as Global did here. However, it does mean that tenants will have to very carefully consider the definitions of premises when complying with vacant possession conditions. And if those definitions include landlord's fixtures, as often they do, a detailed analysis will have to be carried out to determine what are landlord's fixtures, which should not be removed, and which are tenants' fixtures, which can be. If you found this useful, please comment, like or share the video. I'll see you soon for another Tomkins Talks. I hope you and yours stay safe and well.